Hi guys, it's Kathy. I hope you're doing well. We made it to Monday morning. Oof. Oof. Monday. Okay. I got this mostly this judge today. I love her. She does a really good job. I did throw one more clip in the middle of a different judge, but then we come right back to this judge. You put yourself in that orange jumpsuit. Yep. They do. They put themselves right where they are. All right, here we go.
3M 196.
Good afternoon, Your Honor.
Your Honor.
Andrew Lotto, 60308 for the record. And I have Mr. Norman approaching me
All right.
to the podium.
Right. 23M 196. This matter comes on a hearing on revocation of probation. Mr. Norman is present in custody with counsel. And how are we proceeding today?
Your Honor, I've been having discussions with the people. The initial, 1 second.
Okay.
Let's go, sir. You're wasting my time.
Your Honor, Mr. Norman's willing to essentially plead to his offense, that being not complying with probationary terms.
Okay.
We're leaving, my understanding from just discussing it with the people, pursuant to our discussions, it was 7 months jail was what was up for debate. The people are graciously allowing us to argue open to the court with, I believe, what would be a cap of 7 months, because people are going to be asking for 7 months, but I'd be asking for 4 months jail.
Okay. All right. And what is the admission to?
It's to non-compliance of probationary terms.
Okay. Any term in particular that you are going to be admitting to? Do you know? It doesn't matter to me. I'm just asking.
All of the above. I mean, just not.
Your Honor, just to not completing classes and not actually speaking with probation.
Okay. Sorry, I'm just pulling up the complaint and report now. Hold on. It's taking a minute. Okay, so maybe condition number 8, failure to perhaps re-enroll in counseling or something of domestic violence.
Yes, Your Honor, that sounds sufficient.
Okay, all right. All right, is that the agreement of the parties?
Yes, Your Honor.
It is, Your Honor.
Okay, all right. All right, so Mr. Norman, your attorney has indicated to me that that is what you wish to do today.
Yes, ma'am. Yes, Your Honor.
Okay. You probably heard me go through this with another individual just a minute ago. So essentially, you'd be making it an admission rather than having a hearing on this matter. You can have a hearing, however, on this matter. Do you understand that?
Ma'am. Yes, Your
Okay.
Honor.
And you have the right to have your attorney represent you at that hearing. You have the right to have, we're trying to set that hearing today. We were trying to have it within that 14 days of you being in custody. That's why it was set today and important to have it today, because you have a statutory right to have it within that 14-day time period. You understand that, sir?
Yes, Your Honor.
Okay. And you'd have the right to have your attorney represent you at that hearing. The requirement to have the district attorney prove the allegations in this complaint and report by a preponderance of the evidence. All right. That's the legal standard in these hearings. You would have the right to confirm confront any of the witnesses that the district attorney would put on to make his allegations and prove them. Your attorney, you'd be able to see and hear those witnesses. Your attorney would be able to cross-examine those witnesses. And you could also put on witnesses as well, and you could put on any legal defenses that you might have at that hearing too. And you could also testify at that hearing in your own defense as well, or not testify. And no one could make you testify if you chose not to as well, because you do
I like this judge too.
not bear any burden of proof at that hearing too. Do you understand that, sir?
Yes, Your Honor.
Okay. Additionally, if I were to find that you did violate the terms of your probation, you would also have the right to appeal any finding that this court made to a higher court as well. Do you understand that?
Yes, Your Honor.
Okay. But once you make an admission on that, you give up those rights. Do you understand that?
Yes, Your Honor.
Okay. Do you still wish to go forward with this admission?
Yes, Your Honor.
Okay. And the agreement that is being made here today is that it's capped at 7 months as to what this court could impose. But your attorney is going to be asking for less than that. It sounds like a bottom range of 4 months. Is that what I'm understanding, between 4 and 7 months here?
Yes, Your Honor.
Okay. And I assume there's going to be credit for time served as well that has been already imposed.
Correct.
Not only the 14 days that's already been imposed, but whatever has been imposed previously, correct?
Correct, Your Honor.
All right.
And I don't have that time computation for you, but I can actually file that with the court today, later on today, if not tomorrow.
Okay. All right.
But I would ask that any time, credit for time served be after the revocation complaint from probation.
Okay.
Because this has been going since 2023. The initial case, I would ask that he doesn't have any credit for the initial case, or when he was picked up, and when it was when the deferred was revoked, and anything prior to the complaint, this complaint for the revocation of probation.
And Your Honor, obviously that's in your discretion, but my understanding.
Right. I think if that's going to be the case, I think you guys have to agree on that before we go forward. Because if it's going to be just open, I think that has to be an agreement before. And I think that you guys have to talk about that.
One moment, Your Honor, because I don't think that the time computation itself for the entire longevity of the case even reaches, it's maybe 5 more days on top of the 14
Right.
that he served right now.
Sure.
But
Yep.
1 second.
Yeah. I think maybe you have, I thought you would have 14 days right now though, right?
Yeah, so it's
Yeah.
14 days as of right now being picked up for this revocation
Sure.
matter. But in terms of globally and holistically, it's,
How much before that? Right. Sure. Yep.
I don't think he served
I didn't know.
anything.
Before that.
No.
Okay. Yeah. I don't know if you guys can see, can you see that? Oh, I just made my screen go like really tiny. It's bad. Hold on.
Just since like after this revocation.
Let me reopen it again. Hold on 1 second.
Monday. Custody September 26, 2024.
Hours from the states.
I did something to my screen. I can't get my JPUB to open back up.
I cannot see more than 4 days credit because each time he was booked, he was released the same day.
Okay.
Be a maximum of 4 days that I see.
Vera says she only sees about a maximum of 4 days.
He's got 2 days plus the 14.
16 days.
Okay.
It's fine.
Yeah.
Your Honor,
I did, yeah. Did you see what it was doing? It wouldn't open it. It kept going to Control F. And so, and I was like, just happened. I don't know what I did to it.
Okay,
It's crazy.
so you got it.
Now it's back, yes, with big letters too. I was like, thank goodness. I was about, no, what happened?
She muted it. Don't. It's not your computer. Your audio is fine.
Yeah, so
They're just trying to count, and that sometimes
Your Honor,
is
I believe
challenging
it's
for lawyers.
17 days credit time served
Okay.
on this one. Are you amenable to that?
yes.
Okay.
So is everyone in agreement with that?
Yes,
You're fine with that?
Yeah.
Okay, all right. Okay. So, Mr. Norman, it sounds like an agreement of 17 days credit for time served. So even if you got the bottom of 4 months or the top of 7 months, that's what you would get for credit for time served. All right?
Yeah.
All right. And then I might have asked you this already. Is anybody forcing you or coercing you into this agreement today?
No, yeah.
All right. Are you today under the influence of any drugs or alcohol or medications that could impair your ability to understand what you're
Okay.
doing? Okay. Did you have enough time to speak with Mr. Lotto about this?
Yes, Your Honor.
All right. Did you consider this thoroughly, and do you need any more time to consider this?
No, Your Honor.
Okay. But you thoroughly understand you could have a hearing about this, correct?
Completely. Yes, Your Honor.
Okay. And I mean, you are giving up the right to have a hearing. And once you make that decision and you go forward and you make an admission on this complaint and report, you understand you're giving up your right to that hearing?
Yes, Your Honor.
Okay. And no one's making you make this decision? It's only your decision and your decision alone?
Yes, Your Honor.
Okay. And you don't need any more time to think about it. Is that right?
No, Your Honor. No.
Okay. All right. Mr. Lotto, do you believe that Mr. Norman fully understands the rights that he's giving up by entering into this admission to the probation revocation complaint here today?
Yes, Your Honor. We had several conversations as to the possibilities that could happen as a result of going to hearing, essentially the evidentiary hearing and what the preponderance of the evidence standard, that standard is a lesser standard than reasonable doubt. We had a discussion as to all this, and I do believe he's making a knowingly voluntary decision at this point.
Okay. All right. And Mr. Norman, do you admit that you did not re-enroll in domestic violence treatment after you were replaced back on, I guess, probation after the February 10th, 2025 revocation? At some point, there were several re-enrollments and then stopping, and then there
Yes, Your
was
Honor. Yes, it's
there
so
was
old. There's
financial
it's so much-
difficulties, I
it's so
know,
long.
and
Yes,
yeah.
I totally admit what I've done wrong. I'm taking full responsibility. Yes.
okay, all right. All right. Any other advisement that the people would like me to give to Mr. Norman in regards to this prior to going forward and accepting his admission?
Okay.
All right. All right, Mr. Lotto, well, I'm going to find that Mr. Norman's admission in regards to, well, do you admit, Mr. Norman, to violating condition number 8 of your probation conditions that was filed on January 16th of 2026?
Sure.
Okay. All right. I'm going to find that this is a knowing, voluntary, and intelligently made admission to the complaint and report of the probation officer that was filed on January 16th, 2026, sir, that you understand what you're doing here today, that you understand the possible penalties that will be imposed by the court due to your admission to this complaint and report today. Before imposing sentence, I will hear arguments from counsel in regards to this admission.
Well, I don't know. Did you make sure he understands what he's doing here today yet, Judge? V, thank you so much for the cheers. I really, really, really appreciate it.
At this time.
So, Your Honor, Mr. Norman has quite a significant, he has significant health issues. Obviously, you can see, or maybe you can't from the podium, but his left knee, he needs to go see an ortho or another knee specialist. He has skin cancer that he's been having treated for at least the last year, from my understanding. Now, only from his own accounts, but also from Ms. Bender, who joins us in the gallery. Understanding that Mr. Norman has had a difficulty in terms of conducting and completing his probationary tasks, and noting, yes, there have been hot UAs and everything, he takes full accountability, as he just said, in open court, and he wants to take full accountability. However, he does provide still for Ms. Bender. He owns and operates an HVAC company, which my understanding is he operates that alone or maybe with subcontractors of some type. And he also has several houses that he oversees and manages. So doing this jail sentence, he definitely understands that he needs to, based off of everything that has or has not happened over the course of probation. But notably, if he were to be given a 4-month jail sentence for this probationary malfeasance, we'll call it, it will allow him to set things up and potentially get out to help Ms. Bender after those 4 months to establish everything, because Ms. Bender doesn't have the ability to work HVAC, let alone run the company, or to manage the 3 properties. And I believe there's a 4th one that they currently have right now. So she would be suffering financially as well. And that's one aspect I was trying to advocate on behalf of Mr. Norman through Ms. Bender's. And again, I understand that she is the alleged victim in the case, but they have reconciled whatever has or did happen. And now it's just up to Your Honor as to whether or not to allow him to serve his sentence appropriately for those 4 months and get out and be a law-abiding citizen otherwise, as well as a husband.
Right? The people?
Your Honor, frankly, I find the defendant's argument quite odd, that he should be out to be able to manage his 3 properties. It's essentially asking you to treat the wealthy differently than anybody else. Mr. Norman was charged with a violent offense. This was a particularly violent episode where he continued to be...
Wait a second. Stop. Did you just say you found it odd that the lawyer asking the wealthy to be treated different is odd? Sir, that's not odd. That's Monday. That's norm. Odd would be maybe someone who didn't own 3 properties getting special treatment.
Took the victim into the bedroom, continued to to throw her to the floor, punch her in the head. He continued this assault. He spit on her numerous times as he was hitting her. And then he was given every opportunity in the world, Your Honor. He was put on a deferred sentence, which was revoked. And then this particular revocation of the probation, which was his second chance there, this was filed back in January.
Monica, thank you so much for the gifted membership on Twitch. I appreciate it. Thank you so much.
Like months and months ago, while this case was continued because of his prior attorney's health issues, this court continued to give him opportunities to get into compliance. And he didn't, and he ultimately had to be picked up on this warrant 2 weeks ago. Nothing shows that he has taken the domestic violence treatment seriously. And so the people would ask for the full 7 months. Also, we would ask that the court hear from probation prior to sentencing.
Your Honor, I don't
Right.
have much to add, as I have outlined numerous times before the court before. Unfortunately, the status of Mr. Norman's progress and compliance with probation has not improved since the filing of the complaint in January of this year. It is unfortunate that Mr. Norman has not been able to get some of these things in order when it comes to his finances and his health the way that he likely had hoped. However, affording him additional opportunities in the future obviously was not something probation could get on board with, because there's nothing to show that anything would look different, which is why probation is at the position of asking for this to be finalized with a jail sentence. I understand that Mr. Norman does have some barriers in front of him, but I think that there's just been too much conflicting information provided to probation than what's been provided to the court, and a lot of open-ended promises that were never made. So I just would like the court to take into consideration that probation is asking for a jail sentence. However, it is not something, the length of time is not something probation is able to provide to the court, and would leave it to the court's discretion.
Okay. All right. Any last statements, Mr. Leto?
Your Honor, I'll keep it brief. Mr. Norman obviously had financial straits. I don't believe he is classification of wealthy, but again, that's up for debate. But in terms of the warrant being issued, that was issued, and my firm can take account for that, just to say our impression as to the minute order was to say that if he didn't have an attorney by the next court date, that he would be taken into custody, us sending him essentially a virtual link to appear virtually, such as I did when I was at that court date when you issued the warrant. And that's not at the last court date, but the one previously. Yes, he turned himself in when he came into court at the last court date. I would just note that he wasn't stalling for any reason at being taken into custody. He was putting everything in line in terms of his businesses to make sure clients weren't unanswered and things didn't fall through the cracks. That's why he didn't turn himself in at the last court date, and he turned himself in when we appeared at the last court date.
Well, I appreciate the, taking accountability now at this point in time with the admission and for the probation revocation. I honestly wished there had been just compliance for the probation. That was what, when we first started on this path, when I took over this case back in March, I had wanted to see. That is what I had hoped was going to happen, and what I had wanted to see for Mr. Norman, and what I had encouraged him to do with his prior attorney was to get in compliance with probation. I wanted to see him get into compliance with treatment. That's all I ever want to see a probationer do. That's what I want to see everyone do, is just take your probation and run with it and be successful. What I would have liked to have seen is you do domestic violence treatment, because honestly, I think that is what is important in these cases, to do the treatment and learn from it. And I think from reading the probable cause affidavit in this case, it was very necessary, because I do agree with the district attorney's assessment that what is stated in this probable cause affidavit was a very serious offense. Honestly, it's one of the more serious offenses I have read. And I have been doing this for quite a long time. It was a violent offense. They talk about you punching her in the head, spitting on her, slamming her against a wall. choking her with the hoodie of her sweatshirt. She could have been very seriously hurt. She did have contusions on her head, choke marks on her neck. She was very seriously hurt. That was one of the more brutal physical attacks that was laid out in any probable cause affidavit I have read. That was very clearly denoted as a very clear domestic violence incident between the two of you. And you needed domestic violence treatment, period. And all I wanted to see you do was get back into domestic violence treatment. And that did not happen, no matter how many times you kept coming back into court. And that very well could have been your prior attorney. I don't know. I don't know what was going on with him, but I kept saying, get back into treatment, do it, comply, see your probation officer, start getting this done. And you didn't do it, you didn't do it, you didn't do it. And that's how we got here, and that's how you got into that orange jumpsuit. No one did it except for you. And that's how you're in this situation right now. You were given opportunity after opportunity, and that has nothing to do with your financial situation. That has nothing to do with anything except for the fact that you were given opportunity after opportunity. Period. You were given a deferred judgment and sentence. That was opportunity number one. That was revoked. Then you were given probation. You were given opportunity after opportunity to comply with that, and you didn't do that. That has nothing to do with financial situation, although other people with lesser means would not have been given that many opportunities. And now we're here. And so you have to face the consequences of your actions. And I don't know if there's a substance component to this or not. Maybe it is your physical difficulties that contributed to it. I did read the letter that was provided by Angela Bender, but honestly, I have to take that with a grain of salt, considering that she is a domestic violence victim, and some of the things that she wrote in there, there's a lot there that when I look back at some of the things that I have read through the lens of the cycle of domestic violence, it comes all the way around to reading through the lens of a domestic violence victim, honestly. But maybe the two of you are the exception to the rule. I don't know. I can only hope. But without you going through any kind of treatment, I worry. I really do. I worry that if the two of you are still together and living in the same type of situation, that I don't know what will happen, especially with the level of violence that was indicated in this case. It very much worries me, I can tell you that much. When I think of the things that worry me and the things that I have to consider when sentencing someone, I have to consider not just punishment, but deterrence. Deterrence not just to you, but to other members of the community. I have to consider rehabilitation. Unfortunately, you were offered rehabilitation and you didn't take it. But maybe in sending you to jail for a little bit of time, or more than a little bit of time, I don't consider anything between 4 to 7 months a little bit of time. That is a significant amount of time, and it will have a detrimental effect on your business no matter what amount of time I give you, I think. It would to anyone. But hopefully that will be rehabilitative no matter what I do here for you, because it'll give you time to think. I would imagine even just the last 14 days gave you time to think. But the factors that I have to take into consideration, sir, I just don't want to ever see you here again. And I don't want you to see you ever in a courtroom ever again. But I don't know how you're going to address any of your other concerns because you won't have the treatment that I really think you needed. That's what I think is the downside here. At this point in time, I think the most appropriate sentence in this matter is going to be 6 months in the county jail. I don't think maxing you out at 7 is nearly appropriate, but I think 6 months is appropriate here. That is what will be imposed. I will give you the credit for the time served that you have earned on the matter. I don't think 4 is appropriate here because I think the violent nature of the underlying offense warrants something much more significant than 4. But I think 6 is appropriate. So that is what will be imposed by the court at this point in time. Is there any other statement you would like to make yourself at this point in time, sir?
Your Honor, I'd like to apologize first for making this as difficult as I have for everybody involved. As far as the treatment for the domestic violence and the anger, I was very successful initially, and I got a lot of homework done, and I did grow, and I understand how severe this is. I raised 2 daughters of my own, and this is no joke, but I did get a lot of counseling done with Aspire, and Kate helped me with a lot of stuff, so I have got a lot of good training from my therapy. I just want you to know that I do know how serious this is, and I take it to heart, and it was a bad place, bad time, but I'd completed over 85% of my stuff, and we are where we are because of me and not being responsible. But I just want you to know, as a human, I got a lot of good counseling out of Aspire, and Kate helped me along the way.
Okay.
I just want you to know that.
Okay. I'm glad to hear that, sir. And I hope honestly, when you are released from custody, that things can be good between you and Ms. Bender. And I hope that things going forward in your life are better.
Thank you.
I really do hope for that.
It's time to grow up as far as my responsibilities. And this
Yes,
was a responsibility I didn't make a priority.
right.
So I apologize for disrespecting the system, Kate, and most importantly, my wife. And Jill, yeah, it's hard, but the homework that we did at Aspire and the counseling initially, it was very healthy for my mental whereabouts with domestic violence.
Right.
It makes it to a new level when I see it on TV. And yes, this is 3 years old. And so ultimately, it's not me making this priority like I did everything else. And I apologize.
Well, and just think about that, though. You'd never want your daughters
I
to be in that situation, right?
Yes, ma'am. And that's
Right.
what I'm saying. The homework and the counseling I went through, unfortunately, like you said, you wish I just would have completed it, and I didn't prioritize. So that's my fault. I'm here looking you in the eyes. But I got a lot of tools and homework that I still use from Aspire Counseling and Kate. And I'm proud of leaps and bounds. And that's why my wife and I are still together. It's just I didn't prioritize finishing.
Right. Well, I'm glad.
I want you to
hear-
believe with your choice that
I do believe
the
that.
counseling did help.
All right. I do believe you, and I hear that.
Yep.
I do hear that, sir.
Thank you. And thank you
I
for your
think
wishes.
this right now, I think right now is just the consequence. And then once you serve this consequence, you can move on and get past it.
And I never
Right.
want to see you again in
I
a polite
agree.
way. In a polite way.
Not here, right?
No, yes, ma'am.
Yeah.
That's the door. Hold the
Right.
door open for you. Yes, ma'am.
Right, sir. Okay.
Yes, ma'am.
All right. So I think this is what it is. You face the consequence and you move on and you'll get past it.
I will.
All right?
We will.
Okay. All right. Anything else you'd like me to know?
No, ma'am.
All right. Then I do wish you the best.
Thank you.
Mr. Holman, okay? You'll serve this time and then you'll move
A
past
lot
it.
better.
Yes, you will. All right? I do believe that too. Okay?
Yep.
All right.
I can't say that I'm sitting here wishing him the best, because I don't wish him the best.
All right. So that'll be the order of the court at this point in time. All right? Anything else you'd like to say? Or anything else?
Again, apologize. I don't want to
No,
be, I don't want
you don't
to
need to. All right. I hear you.
don't
I
want
hear
to be
you.
less. I'm sorry for
I
wasting
know.
everyone's time in the courts. And I'm better than that. This and Kate will verify that, but the rules are the rules.
I know.
And
And I
Kate did
know-
everything she could.
I know. And I know Ms. Bender is here. Ms. Bender, I did read your letter. Was there anything else that you wanted to say? All right. Okay. Thank you. Mr. Lotto, anything else?
No, Your Honor, thank you.
All right. All right. Anything from the people? Otherwise?
No, Your Honor.
All right. Ms. Ryder?
No, Your Honor, thank you.
Okay. All right. Thank you, Mr. Norman. I do wish you the best. All right. Thank you, Sid. Do you need to sign that order?
We're on the record for the 11 a.m. docket for 10 August 2026. Accordingly, 24 CR 22, 23 CR 3110, 23 CR 3899. I'm going to note that defendant made an admission to violation of probation on April 27th, 2026. There's been a PSIR done. There's also a CAE acceptance letter in the file. The minute order reads as follows. Sentence to be revoked and open to court. All right. So with that, let's go ahead and, Ms. Pritchard, are we ready to proceed?
Yes, Judge. However, it's a little bit, I think the possible sentences are a little bit more nuanced than that. It's actually the same as was outlined in the plea paperwork. So it is open to the court. However, there's a cap of 12 years community corrections or 8 years in the Department of Corrections.
All right. People's position on sentencing, please.
Yes, Your Honor. The court has before it the range of sentencing for the DF2 in the 24 CR 22 case, as Ms. Pritchard indicated.
I'm so sorry to interrupt, Judge. I had one other thing that I wanted to address before we move to sentencing.
Okay.
I just don't want him to do his whole argument. The court did order updated PSIRs, which there was some back and forth about that. We did get something filed on, I think, August 6th, but it does not go into any kind of detail about 24 CR 22, and I'm not clear as to why. The other cases are discussed, and they've asked Mr. Hammer about them, but there's not anything like that for 24 CR 22. So I would be objecting to this PSIR as insufficient and not what the court ordered.
All right. So what then are you asking me to do?
I'm asking the court to reset sentencing one more time and ask them to file a complete updated PSIR that includes 24 CR 22.
All right. What's the people's position?
I object. I ask that the court proceed to sentencing today. The reason being, there was a PSIR filed in 24 CR 22 when this case was originally resolved. And the complaint information or the complaint reports have documentation of the complaints and the violations of probations, and so too does the newest PSIR that was filed in 26 CR 22, indicating the violations that the defendant has had on probation. So I do believe that the information before the court is sufficient for the court to resentence today. So I ask that we proceed.
Okay. I agree with that position. The violations were similar, and while it does not specifically mention it, the behavior has been well documented, and so we're going to go ahead and proceed. All right. People's argument, please.
So, Your Honor, before the court is a wide variety of sentencing ranges, so I want to be clear about what those are. In the 24 CR 22 case, as Ms. Pritchard indicated, there is an agreement based on the defendant's admission to violating probation that the sentencing range available to the court is, if DOC, between 6 and 8 years, if community correction, between 6 and 12 years, or probation. So all the sentencing available to the court at the time of the original plea. In the earlier cases, 23 CR 3899, the court has a sentencing range of 1 to 6 years. There is no constraints on that sentence. And then in the 23 CR 3110, the sentencing range is 1 to 3 years without constraint. So really the controlling sentence is the DF2 in the 24 CR case.
All right. And what are the people asking that I do?
Your Honor, I ask that the court impose the suspended 6-year Department of Corrections sentence that was discussed previously at sentencing. It's clear that the defendant continues to engage in criminal activity. He is not complying with the stipulations and the terms of probation. He has been remiss in his obligations to get drug and substance abuse monitoring and treatment. He's tested positive for narcotics. The 24 CR case implicated DF1 charges based on felonious quantities of controlled substances in a gun, but he received the benefit of a bargain, and further still for the DF2 lopping off the top end of the sentencing range. So being on felony probation for 3 cases and not complying with the orders of the court in terms of that sentence indicate that the defendant should be sentenced to the Department of Corrections, especially considering the probationary sentence at the last time the defendant was sentenced. The court did indicate that he was on a 0 tolerance for his probationary sentence. So I'm asking that the court impose the 6-year DOC on the 24 CR case, the 6 years available for the 23 CR 3899, and 3 years for the 23 CR 3110. If the court does find it appropriate to sentence the defendant to community corrections, I am asking that the court impose the high sentence of 12 years to community corrections. But again, I am asking the court to sentence the defendant to that 0 tolerance, 6 years suspended sentence that was originally encompassed in the sentence.
And so in 23 CR 3899, what was the request again? I got 3110, which was 3 years.
6 years, Your Honor, which would be the high range of the enhanced range for that Class 5 felony.
Okay. All right. Good. Just want to make sure I understood. So let me review 24 CR one more time. 6 to 8 Department of Corrections, or 6 to 12 for probation or community corrections, correct? Actually, it's a 6-year stipulate. Okay. Is that correct? Do I have it accurate now?
I believe so, Your Honor. I don't believe that the court is limited on how long they can sentence to probation, but if it were to be community correction, to be 6 to 12.
Okay, good.
Such a good kitty.
Ms. Pritchard?
Yes, Judge. We would be asking that the court follow the recommendations of Mr. Hammer's probation officer and the probation department and sentence Mr. Hammer to community corrections. I think that there's good reason for this recommendation, and it's made by someone who has worked with Mr. Hammer for the past few years. The probation officer does note, I just missed it here, that Mr. Hammer's attitude towards probation has always been respectful, and that he has consistently reported for his probation meetings. Obviously, there are some problems with how he's shown up for probation, but I think that his attitude and the progress that he has made on probation do make him a really good candidate for community corrections. He just needs more support addressing the struggles that he had, which I think are largely related to addiction. It's unfortunate that he doesn't qualify for drug court. I think that would have been a very good sentence initially, and I think it would be a great option now, but it's simply not an option based on the level of charge here. I do think that the court can see in the differences between probation or between the PSIRs that this time on probation has really made a difference for Mr. Hammer. Really just based on how he takes accountability for what he's done and that he recognizes the harm and the reasons for committing the crimes that he did. It reads very different between 2024 and 2026. So I think that there clearly has been some benefit from being on probation. Obviously, he hasn't engaged in treatment the way that he needed to. Part of that has come down to costs and what he could afford. And he's been working very hard, over 40 hours a week recently, to be able to pay back what he owes so that he can restart treatment with the provider. He understands that that might not be an option for him now. But if he were to be sentenced to probation, that's what he would do. ComCore would allow him to continue on treatment, whereas a DOC sentence really doesn't. It would also allow him to continue to work in the community. He has his own business that he runs with his wife, and he provides for his family.
Maybe report PSIR, maybe.
With that, he has 2 children. One is a 15-year-old boy, the other is an 8-year-old daughter. His 8-year-old is autistic. And so the impact that him going to prison would have on her is really great. And it's something that Mr. Hammer takes very seriously. And he, I think he'll speak to this, but he wants more than anything to be able to be there for his daughter and provide for her. And obviously ComCore would be a big change for her, but much less than prison. I think that the goals of sentencing are better met by sentencing him to community corrections where probation is indicating they think he can be successful. They would not have recommended that otherwise, and where community corrections themselves believes that he may be successful, or else they would not have accepted him. So I think that safety of the community and addressing the underlying reasons for these law violations, those goals are better met in community corrections. And I think that Mr. Hammer can do that. So we are just asking the court to give him that extra structure and support. It is also a punitive sanction to go from probation to community correction, so that goal of sentencing is also met. We are also asking if the court is going to grant Mr. Hammer the opportunity at community corrections that he be given a date to report in 2 weeks.
I'm just going to interrupt you. That is not the practice of this court. You know that yourself, and I will not make any exceptions for that whatsoever.
I understand, Judge.
Yo, my mods are the kings and queens of shenanigans. 100%.
I would like to make my request.
Sure, go ahead.
Mr. Hammer, as I said, he owns a business. He has outstanding contracts and needs to make good on that and provide for his family. So that would be our request, Judge. I think that Mr. Hammer's wife is present. I'm not sure if she wanted to speak. She looked very nervous. So if I could follow. And she would, Judge, if we can just allow her to do that. I'm sorry. What was your... Judge, this is Kathleen Hammer.
All right, ma'am. Please come to the microphone, speak directly into it, and make any statement you wish to, please.
Good morning, Judge. As she previously stated, my name is Kathleen Hammer. Kyle Hammer is the co-founder of our business, Hammer's Custom Tile Incorporated. He's also my only employee. Excuse me. He also helps me parent our 2 children, Hunter, who is age 15, and our daughter, Raina, who's 8, who is also autistic, and her daddy is her world. And when I say she is so attached to him, I'm probably understating that. And last but not least, he is also my partner in life for 17 years. We have had our ups and downs, and we're halfway. But what marriage hasn't had its ups and downs?
Okay, I'm calling bullshit right now. Because if you're married 17 years, you're ready for a vacation. She's ready. She's ready for a little vacation from him. Monica, thank you so much for the cheers. Thank you.
I continue to show my support to him as he has supported me through 3 different cancers, the last one being breast cancer, when I had a double mastectomy with reconstruction, and he was there with me through every step of that process. And I will continue to support him as he has supported me. And there's no one else I'd rather go through life with than him. Thank you, sir.
Thank you. Does your client wish to make any statement?
I think so, Judge.
Okay. Hello, my name is Kyle Hammer. First and foremost, I want to apologize to you, Judge, the District Attorney, and the good people of the state of Colorado, and mostly my family. The actions I have done to be in this situation was extremely wrong of me and putting the citizens and police in danger. I was a drug addict at the time and have been doing really well in my sobriety. I continue in my recovery because of my family, my wife, my 15-year-old son, and my 8-year-old autistic daughter, who absolutely needs her dad. I am a co-founder and partial owner of Hammer's Custom Tile and Floor Coverings. My wife and I started in October of 2017. Our company also took a hit because of my irresponsibility decision, but we still kept it alive, and I want to continue to build our business. I have currently 3 contracts signed between me and homeowners right now to start work as of tomorrow. So, Judge, I ask you, please, in whatever decision you make today, to allow me to continue to work and be able to be there to tuck my daughter in every night and read her a bedtime story, because she struggles to sleep without me. I would like to continue on probation just to prove to everyone that I can complete it, but I know that's a long shot because I have messed that up. But I have completed almost 3 of the 6 years, and I hope for that accounts for something. If not probation, I understand that community corrections would not be a bad spot for me either. I just hope you'll give me a chance to report myself in so I can continue to work these contracts and be there for my family. I'm really trying to make amends for what I did. I have a family to think about, so I'm not going to run. I'm not going to skip reporting in. You have my word on that. Whatever you decide to go that route. Thanks for your time to hear me out and say what I needed to say.
All right, thank you. I'm going to note that 24 CR 22 is specifically addressed in the PSIR, in which the report writer made a report that Mr. Hammer did not take accountability for his actions. And so I'm going to find again that the PSIR is adequate for today's purposes. All right. Additionally, I've heard the statements of the people. I've heard the argument of defense counsel, the statement of the defendant and his spouse. I've also reviewed the complaint and report of the probation officer and I've reviewed the purposes of the sentencing code, and I also reviewed the plea agreements in the various cases. At the present time, I'll be candid, I'm not particularly persuaded by Mr. Hammer. And my rationale is as I review the criminal history, 24 CR 22 shows 6 years supervised probation, in which a suspended DOC sentence was also ordered. I'll note that there was then followed by there were additional convictions for driving under restraint and the like. And then I hear that that Mr. Hammer wants to be there for his daughter. I have no doubt at some level it is. That's true. But it wasn't sufficient enough, sir, for you to comply with the terms of your probation. You knew precisely what you were to do, when you were to do it, and you failed to. So when you come in here now and tell me that your daughter's the most important thing, sir, that's simply not true based on the record that I have before me and that was acknowledged by you when you made an admission. Additionally, you knew today that you were going to be facing potential sentence to the Department of Corrections. While I am sympathetic, particularly to your wife, who has apparently stood by you through some extremely difficult times, the fact that you have outstanding contracts simply has no weight on my decision here today. You were well aware of the consequences of your action. You were given repeated opportunities to comply, and you failed to do so. So at this point, I will adopt in part the recommendation made by the people. I'm going to order you to 6 years of community corrections. You're going to be remanded into custody today. That will be in 24 CR 22. Additionally, in 23 CR 3110, I'm going to order that you serve 3 years in community corrections. Likewise, in 23 CR 3899, I'm going to sentence you to a 6-year term in community corrections, all sentences to be concurrent one with another. I'm going to remind you that should you fail to comply with the standards established for you in community corrections, the Department of Corrections sentence will remain on the table. If you really care about your family, as you have indicated that you do, now is the time for you to step up. And so I did, as I note, consider the sentencing guidelines, and I'll briefly address those at this time. That one of the purposes of sentencing is to ensure that you receive the sentence that you deserve. I'm going to find that based on your inability to comply with probation, it is necessary to place you into community corrections to protect the public at large. This is treatment that is similar to what other defendants in this court have received, and so I'm fine that your sentence is fair with relation to like situated defendants. Additionally, I'm finding that the sentence itself that I have imposed is appropriate because it's likely to promote rehabilitation, yet also require you to take accountability for your actions. And so with that, that will be the order of the court. And as I've indicated, I'm going to order that you be remanded immediately. Ms. Pritchard, anything else that you think that I should address, but that I have failed to do so?
Just the credit for time served, Judge.
I'm sure in 3 days. Do you have something different?
It's, yes, so it's 3 days in 23 CR 3899.
Okay.
2 days in 23 CR 3110, and 1 day in 24 CR 22.
Any objection to defendant receiving credit time served for those days?
None, Your Honor. Sorry to interrupt.
Not a problem. In 24 CR 22, Mr. Hamill will receive 1 day's credit. 23 CR 3110, 2 days credit. 23 CR 3899, 3 days credit. I'm going to conclude my remarks to Mr. Hammer. Mr. Hammer, I appreciate.
Okay, he's not going to prison. So you know how when judges say no tolerance? Oh, okay. I lost my stream for a second, but it looks like it came back.
Fulfill that responsibility. If you are serious about taking accountability for your actions, now is the time while you're in community corrections to do precisely that. And so that's the order of the court. All right. We'll be off the record.
Are we back to normal now? Can you hear everything now? I don't know what happened. It just dropped my stream for a moment. I'm going to pause it until I know if you guys can hear anything. Okay, Sherry said yes. Thank you, thank you, thank you.
Are you Mr. Valverde?
Yes, ma'am. Yes, ma'am.
Right. Did you have an opportunity, sir, to watch a video advisement of your rights?
I said, when judges say zero tolerance, it's bullshit. He didn't get prison.
Yes.
All right. Did you have any questions about that, sir?
No.
All right. Sir, my name is Elizabeth McClintock. I'm the county court judge for Teller County. It is August 10th. I was going to be doing a advisement in regards to your the possible penalties in case 26M278. The allegation in that case is a tampering to charge. We were going to be covering the possible penalties in that case. I did find probable cause for that allegation in that case. We were also going to be covering setting bond in that matter. Hold on one second. I'm having a hard time getting my thing to come up here. So we're going to be discussing bond as well. Did you have any questions about that, sir?
I have a lot of questions, but I don't know what to ask. This is my first time getting in trouble for something like this. And
okay.
I was just trying to get some help.
All right.
And I think, Mr. Valverde, an attorney would be able to speak with you more in depth about questions you might have about the facts of your case, just to give you a heads up about that.
Okay.
And until the discovery is released in your case, sir, basically all anyone is going off of right now is just the probable cause affidavit. That is all I have seen, sir. It is just basically...
Community corrections is like... He does get locked up at first, so they did take him into custody, but he'll take some classes and then he'll get weekends home. And then he'll take some classes, and then he'll get work release. And then he'll take some classes, and then he'll be able to live at home, but he'll have to report. It's just, you go through steps to get out of jail and live at home and work.
Just that. That is all that's been released just to myself and to anyone else in the case so far. Okay?
Okay.
And that's all we're going off of at the moment. All right. As it is, sir, what I have looked at is just the probable cause affidavit. And that's what I found is that there's probable cause to go forward on this class 2 misdemeanor offense of tampering to. The possible penalties that can be imposed, the maximum possible penalty that can be imposed for a class 2 misdemeanor offense is up to 120 days in the county jail and or a fine of $750. All right? That's the maximum that could be imposed. Do you understand that, sir?
Yes.
Okay. And that's what I need to inform you of today. We also need to discuss that there's going to be a mandatory protection order issued pursuant to Colorado Revised Statutes 18-1-1001. It covers an individual named Chelsea Lambert. She was the other party that was involved in this case, and it talks about because I guess there was an intimate relationship between the two of you, that this could be considered an act of domestic violence. I do not find that there was any force or really intimidation involved or anything of that nature. So I'm not going to find that the firearms portion is going to be applicable in this case. But I will find that it is an act of domestic violence pursuant to 18-6-800.3 subpart 1.
I have a question.
Yes.
So the house that is, it's my house, I'm the homeowner, and the restraining order, are you restraining me from going to my own house?
Well, is she living there right now?
I don't want her there. She won't leave. That's why I called the cops. That's why all her stuff, I've been trying to get her to leave and she won't leave.
Well, that is going to be a problem, sir, because if she is living there, you are probably going to have to take an action right now in order to evict her, because at this point in time, this mandatory protection order is going to say that you are not to have any indirect or direct contact with her. And you're the one who's going to have to stay out of the house if she is living there right now. And even though it's your house, you're going to have to take an action in order to evict her.
How do I evict her?
Well, you'll have to go and find you can come to the courthouse and you can get the forms in order to do that, but you have to go and use those forms and take action under the law to do that lawfully.
This is like rage bait. I barely bought the house.
I can't give you legal advice about that, sir, but I would suggest you go and you might have to consult with an attorney about doing that. And I would actually suggest you do that because it's a very tricky situation. So, but right now I have to inform you about this mandatory protection order because at the moment, that's what this says, is you're not to have any direct or indirect contact with her or any communication with her at all. And so if you have to take this kind of action against her and she's in the home, you're to vacate the home at this point in time. You are, yes. So you'll have to take legal action in order to get her out of the home, sir. Yes. All right. Additionally, you're not to harass, intimidate, retaliate against, or tamper with her or any other victim or witness to this charged offense at this time. All right? Specifically, you're to vacate the home and stay away from any home where she might be located and any other location where she might likely be found. All right? And you're to refrain from contacting or directly or indirectly communicating with her or any other witness to the charged offense. Additionally, because alcohol was apparently part of this offense, I am requiring that you not possess or consume alcoholic beverages or controlled substances without a valid prescription while this case is pending. All right?
How long is this case going to be? And how long is
I don't know, sir. I don't know how long it's going to last. But while it is pending, those are going to be the order of the court unless they are modified. All right?
All right.
Do you acknowledge this mandatory protection order, sir?
Yes.
All right. And you'll get a copy of this. I am taking out, though, paragraphs 4, 5, and 6. Those are not going to be applicable in this situation. Sir, it is further ordered, though, you are allowed to have one trip back to your home with law enforcement to obtain any undisputed personal property that you might need in order to set yourself up anywhere that you need to live in the meantime until you can get back into your residence, all right?
Okay.
While you are in custody, sir, you are being represented by the Office of the Public Defender at this hearing and any other hearing while you are in custody, all right? I'm going to have the attorneys who are here, they're in the courtroom with me today. I'm going to have them introduce themselves to you right now so you know who's here, all right? For the people, for the state representative, for the prosecution. Sorry, Mr. Machecha, go ahead.
Stanley Machecha for the prosecution.
All right, and for the defense?
Hi, Mr. Valverde. My name is Abigail Kovar. I'm an attorney with the Public Defender's Office, and I'll be representing you today for arguing your bond.
Okay, thank you.
And I'm sorry, I didn't mean to talk over the prosecutor there, sir, but did you hear everybody's names?
Yes.
Okay, all right. So, sir, we need to discuss setting your bond so that you can know how much you need to post in order to get out of custody today. In posting, talking about bond, the things that we consider, well, if we discuss bond today, bond will not be argued at your next court date unless counsel files a written motion to discuss bond. And that needs to be filed pursuant to Colorado Revised Statute 16-4, 107 or 109. When we consider bond, we consider your individual circumstances, what bond and bond conditions will reasonably ensure that you will appear for court, and then what bond and bond conditions will protect the safety of any individual person and the community at large. Now, we also consider, are you a prior military or current military member, sir?
No.
Okay, all right, because there are resources available to you if you are a prior military member or current military member. Now, we talked about that mandatory protection order. Keep in mind, failure to comply with that mandatory protection order could result in contempt of court or additional violation of protection order charges being brought if you don't comply with it, all right? So it's important that you comply, okay? All right. But let's talk about setting bond. I'm going to let the parties make arguments in regards to setting bond, all right? Anything from the people or from the defense? Like to go first?
It seems like the alleged victim in this case initially said that told 911 that the defendant was actively beating her, and then the story it softened over time. Then there was water poured onto her, and then there was no physical contact whatsoever. But given that she initially said that the defendant was beating her, I would ask for a standard cash property bond, Your Honor.
Okay, all right, and from the defense?
Yes, Your Honor. Considering that the highest level of charge here is a Class 2 misdemeanor, which is what the court found probable cause for, pursuant to 16-4-113, the defense does believe that Mr. Valverde is entitled or presumed to be entitled to a personal recognizance bond. In terms of criminal history, the defense was unable to find any sort of conviction related to Mr. Valverde, which means that he also does not have any failures to appear on his record either. He does have significant community ties. He's been in Teller County for the past 2 years, and he's been in Colorado for 5 years from what he reported on his PR investigation. Of course, he does live in Woodland Park now, understanding the court's ruling with regard to the mandatory protection order. He did also indicate that he works as a mycologist, and he has been for the past 4 years. So he is gainfully employed and attempting to contribute to the community and maintain his own stability through that financial means. So for all of those reasons, we do think that a PR bond is appropriate.
So I'm confused. I show that he was living in Pueblo until recently. And no, because you just bonded out and listed your address as Pueblo in case 26M202, right?
No, I used to live in Pueblo about like 2 years ago. But I was there for like 4 years. I had a girlfriend and we broke up. So I left and I came out here to Cripple Creek, and I've been living in Victor and Cripple Creek for the past 2 years.
Well, you just bonded out in case 26M202 in June and listed your address on Pioneer Road in Pueblo, Colorado.
No, that address is still on my ID. I need to update my ID. I just barely bought the address in 604 Whispering Winds. I bought the house. It's my house.
I'm just looking at court records from another court case where you posted bond.
I just barely bought the house since after that.
Well, it's a court case here in Teller County where you posted bond too. And that was in June. You're going to appear in front of me on August 27th
Yeah,
on that case. So you're telling me either you incorrectly posted an address on one bond and now you're telling me another. So that doesn't give me very good hope that I'm getting the correct information one way or the other. So.
Well, this is, everything's new. I just bought the house in 604.
Right. So somebody needs to tell me some correct information here, one way or the other.
Okay, so.
Does everyone else look at this 26M202?
Yes, Your Honor, I am aware of what the court is looking at. All the defense counsel would point to is that on his PR investigation report, he reported being at this Woodland Park address for 3 months. So that might be where the confusion is coming from if he was initially at that Pueblo address.
Okay, and what about the fact that he's on bond currently when this has happened?
Yes, Your Honor, defense's position on that, we are aware of that case, obviously, but at this point that none of the charges in that case are convictions, and they are pending misdemeanor charges, and he has not failed to appear on that case as he's still yet to be set or yet to be heard on the 27th.
I also have an apartment in Cripple Creek on Bean Car. I've been renting there for about almost 6 months. I can use that address. And I'll be right there in Cripple Creek and I'll be able to make it to court.
Right.
I'm glad I still have that since I can't go back to 604. I need to figure out how to evict her out of my house because I've been homeless for a long time.
Understood. All right. My concern is that one, it's a DV case. Two, he is on bond at the same time. Three, I don't know. Well,
I will show up to court. I am actively trying to relieve myself of this relationship.
Sure. It's all right. I don't need to hear anything about the relationship or the facts of the case or anything like that, sir. But I am cognizant of the fact that it seems very strange what is going on in this case. So at this point in time, I'm going to set a $1,000 PR bond. The reason I'm setting it as a PR bond is that they are not saying there was actual physical touching involved here. And I think that's reflected in the fact that it's a tampering charge and not something else here. I did not find that there was actual physical violence between the two parties. At most, they said there was a dumping of water on the individual and then moving of, I'm sorry, Mr. Maciejczak?
Yes, Your Honor. Well, in the first paragraph, it does say that she was actively being beaten. But then, yes, nobody attests to that in the rest of the facts.
Yeah, and she says that no, he dumped water on her and that. Yeah, I know. It changes significantly into what actually happened or what she said actually happened later. So, and then it was her clothes were thrown out of the house. And it seemed very clear he was trying to get her out of the house. So, which is not a good thing either. That is not how you get someone out of your house. I am more concerned about, it seems like there is some sort of substance use issue going on here. So, but at this point in time, sir, I'm going to take It's probably a risk here, but $1,000 PR bond in your case. I am going to require that you have monitored sobriety, 1 time per week ordered here. I think that's going to be a onus requirement on you here. I'm going to require that you get that set up by Friday of this week. What day is that? I'm sorry. Friday would be the 14th. Is that it?
That's correct.
Okay. By August 14th. So that'll at least give you a few days to get that set up. Because I don't know where you're going to be living, but hopefully you'll be able to get something set up in Woodland Park. But I'm going to, until further order of the court, that'll be 1 time per week, but it will be a $1,000 PR bond at this point in time. I'm cognizant of the fact that you are on a cash surety bond in your other case as well already. So, and that's not being revoked or anything. Nothing is happening there. So that is at least something that's going to be a requirement for having you come to court. Your next court date in this matter is going to be set with the other one. That'll be August 27th at 9 a.m. So both matters will be heard at the same time. Be aware that if you're looking into having the public defender represent you on this matter or the other matter, you do need to go and apply for their representation. And I suggest you do that immediately once you are released from custody. And I suggest you go down to their office in Colorado Springs if you can do that and apply in person. Because it's much easier to do that if you're in person and you take all of your financial documents with you and apply. All right?
Okay.
All right. Ms. Kovar, can you give him any more guidance on applying for that?
Yes, so Mr. Valverde, that's going to be at 30 East Pikes Peak in Colorado Springs. Bring along with you, if you have proof of being on Medicaid, food stamps, or any sort of other government benefits, bring that along with you. Or if you don't have that, bring with you 30 days worth of financial information, and the folks at the front desk will be able to help you out.
Okay. All right, thank you.
And you'll probably have to come to the courthouse here in order to get the self-help forms, or you can find them online in regards to any kind of eviction proceedings, but otherwise you'll need to seek out legal assistance in order to look into anything like that too. So,
Okay.
all right. I can't be any more help to you on that front though. Sorry about that.
Okay.
All right. Okay. But definitely make sure that you go and apply for the assistance of the public defender to help you on these 2 cases, all right?
Yes.
Okay. Any questions at all, sir?
No. Good.
Okay, all right. We'll see you back here then on August 27th at 9 a.m., all right?
Yes, ma'am.
All right, thank you, sir. You have a good day.
Thank you.
All right.
Thank you.
Okay, thank you. All right, we'll be off the record for a few minutes until 1:30. We are back on the record in Division T, Teller County Court for August 10th, 2026. We are going to call the, now I got off here. The Mark Krasinski matter, is that right? Good afternoon, sir. All right, 25M66. This matter comes on for I believe, a revocation of probation complaint. I don't believe that Mr. Krasinski has been advised in regards to the current complaint for revocation of probation that was filed on July 27th, 2026. Counsel, have you advised your client in regards to this revocation on probation?
I have, Your Honor.
Okay, would you waive any further reading and advisement in regards to that?
I would, Your Honor.
All right. So, Mr. Krasinski, I'm not going to advise you further on that, as your attorney has advised you in regards to that complaint that was filed on July 27th and advised you of your rights in that regard. So we'll just go forward with the matter today. I know that your attorney and the district attorney and your probation officer have had an opportunity to discuss the matter, and how are we proceeding, Mr. Schwartz?
Yes, Your Honor. We have a proposed resolution, which would be to revoke and close with 20 days of jail. To kind of give you a background of how we came to that, originally, I spoke with Ms. Flynn. The idea was to, because Mr. Kaczynski has had these like bi-monthly positive tests, of getting him into inpatient. The issue is that when Ms. Flynn met with Mr. Kaczynski and they called sober living, they really couldn't get him in unless he had a like more recent hot UA. And so that's kind of the issue with that. And so given that, right, and given that he's almost done with his probation, it ends in the end of September, and the fact that otherwise he's been compliant and has completed everything he needs to for his DM1 probation, I think 20 days would be an appropriate way in order to close this case out, Your Honor.
All right. So, Ms. Flynn, is that how you'd wish to proceed in this matter too?
Your Honor, probation is recommending to revoke and close with jail. It is unfortunate to give kind of the court a picture of what Mr. Kaczynski has done. It's not that he's not attending treatment. We were previously back here in March when his deferred sentence was revoked. He was given another opportunity with a higher level of treatment. I believe that's when the court added the EOP condition. Mr. Kaczynski has attended 12 relapse prevention classes, 37 individual sessions with his one-on-one therapist. He attended 27 COG skills. So he had substance usage, and then treatment was increased in response to the substance usage. The issue that we're running into is he has periods of clean time with a relapse. And so there's, from the in totality of his supervision, there was use in, I believe it was October, December, February, April, June. So almost every other month there's a relapse. The issue that we're running into is he did have a positive on June 29th. There were some dilutes in July, but the inpatient program doesn't take into consideration the dilutes. They only go on a confirmed positive. So they refer back to that June 29th date. So they did indicate that he wouldn't meet criteria for inpatient. And it just seems that the outpatient level that we've been trying doesn't seem to be working. So it's not that he's not making efforts with treatment. It just seems that we're kind of stuck in this relapsing almost every other month.
Okay. All right. And this is what the district attorney wants to do as well. So,
like probation said, it's not ideal, but I don't think we have many other choices.
Mr. Kaczynski, and I'm sorry if I'm not saying that correctly.
No, that's fine. You are.
Okay. All right. Is this how you wish to proceed in this matter?
Yes, Your Honor. I don't know really what else to do. I've been through counseling and stuff, and I'm willing to go to the rehab, but I guess I gotta, be worse. I don't know. I'll go this route.
It's difficult. You're in a difficult situation. You just,
Yes.
Substance use is just one of those things that comes and it goes, and you have to just keep working on it and trying, and
That's
it's
correct.
going to come, and you're going to try, and you'll come back to it, and
It's a daily thing.
you'll have, right. It's something that you're going to have to deal with every single day, and you'll have relapses, and someday you won't.
That's correct.
And so all you can do is just keep trying. And so, and unfortunately, probation can offer you services while you're on probation, but otherwise it's really just always going to fall on you to keep going back to trying to address what you can.
That's correct.
And so I think what resources are available to you in the community that you have available. There's always NA. There's those types of resources, and you're going to have to seek those out on your own always. So I guess this is all that's left right now. So if this is what you're comfortable doing, I'll accept doing that.
Okay.
If that's what you want.
Yeah, I'll agree to that.
Okay. No, I would have rather have seen you, first of all, just be successful on the deferred.
I would have too.
Right. So hopefully this will be the end of this case, and hopefully you won't have another case, and
Right.
maybe you can seek out the resources that are available to you in the community. Do you have Medicaid or Medicare or anything? Okay. So maybe some of those, I know those are getting cut back too, though. But hopefully you can seek out NA or AA or anything to see if that you could. But again, it falls on you to seek those things out.
That's correct.
Right.
It's my decision that I have to get help and use my tools to get it.
Right. And you're aware of medically assisted substance abuse treatment, right?
Yes, ma'am.
So, okay. So, I mean, I'm not really familiar with what your drug of choice is, but if there is, methadone or something like that that you can seek out,
Right.
is that helpful to you at all?
I don't think it is really.
Okay.
I mean, I take medication, daily,
Okay.
like prescribed medication from my doctor,
Right.
but I don't have a problem with that part of it. It's just something else so that I just get this urge and I end up
Right.
in the wrong place at the wrong time.
Understood. And are you a veteran at all, sir? Okay. So I honestly, my husband was sending me, my husband works for the Veterans Administration, and he sent me a thing yesterday where the Veterans Administration just sent out a flyer talking about how they are now encouraging veterans to seek out, honestly, GLP-1 subscriptions for substance abuse, not just for alcoholism, but other substances. And they are looking to have veterans look into that because they are showing that GLP-1s are helpful for addictions. So you might want to check into looking at the VA and seeing.
I was thinking about it in the back of my mind, but I never did pursue it because it all came down so quick. So
I'm going to encourage you to try to do that because they are finding out that those medications are very helpful.
Okay.
For all sorts of addictive behaviors. So,
well, thank you.
Okay. So maybe look into that because the VA is opening up a lot of avenues for veterans in that regard. Okay.
Okay.
Because literally just yesterday, he sent me a flyer on that. Okay.
I was just trying to see where they're located. Oh, it's in Denver.
Right. So if the parties are in agreement with that, is there credit for time served?
You have no credit, right?
I don't know.
I don't believe so, Your Honor.
All right.
I haven't spent much time in jail.
Okay. All right. This might be a little bit difficult for you then for those 20 days, but you're going to have to tough that out too as well. I don't know what the situation is today. Okay. All right. All right. You do understand though, in regards to this revocation, you do have a right, of course, to be represented by your attorney on the revocation. You have a right to a hearing on the revocation where the onus to prove the revocation, I assume it would be an admission to, well, I guess really the only allegation here is that a failure to complete condition number 6, not to use alcohol or possess any controlled substances without a prescription or in a manner that is inconsistent with a prescription. It was just condition number 6. Is that the admission here?
Yes, ma'am.
Okay. You have the right to require the district attorney to prove that you failed at that condition by a preponderance of the evidence. At that hearing, you could require the district attorney to put on evidence and witnesses at that hearing. You could see and hear those witnesses, and your attorney would be allowed to cross-examine and confront those witnesses. Do you understand that?
I do.
Right? You would be allowed to put on any defenses that you might have to those accusations. Additionally, you could put on any witnesses that you might have to contradict those accusations. And additionally, you could testify in your own defense in regards to that. And you could refuse to testify as well, and you would not be required to testify at all. You have a constitutional right not to testify at that hearing too. And that cannot be used against you as well. Additionally, any admission that you make to this has to be a voluntary admission, and it has to be a knowing admission. So no one can force you into this, and no one could coerce you into doing that. So would you say that your decision to make this admission to this, to saying that you violated this condition is your decision alone?
Yes, ma'am.
Okay. Nobody's forcing you into that today?
No, ma'am.
All right. And you fully understand that you're making this admission, and the requirement of this, the sentence is going to be that you're going to be serving 20 days in the county jail?
Yes, ma'am.
Okay. And then it's going to be closed out. The case is going to be completely closed out after that. You understand that?
Yes, ma'am.
Okay. All right. Sorry, is there anything? Okay. Sorry, I just saw your hand moving. Sorry, I was like, am I missing that? Okay. All right. Wanted to make sure. All right. You understand that if you had been put in jail or anything like that prior to this, you'd have the right to bail in regards to this. You understand?
Yes, ma'am.
All right. Obviously, you're not in custody at this point in time, but you understand. If you had been in jail, you would have the right to a hearing within 14 days. If you were in custody, you understand that as well. Okay. But at this point in time, no one's coercing you, forcing you into this. Do you need any more time to discuss this with Mr. Schwartz, your attorney?
No, ma'am.
Okay. Today, are you under the influence of any drugs or alcohol or medications that could impair your ability to understand what you're doing?
No, ma'am.
All right. Mr. Schwartz, do you believe that your client is making a knowing and voluntary decision to give up his right to a hearing on this matter and to go forward with this admission?
I do believe so, Your Honor.
Okay. And do you think that he needs any more time to discuss this with you before going forward?
I do not believe so, Your Honor.
All right. So, Mr. Kurczynski, sorry about that.
It's like you have a shin on your leg.
I get it right sometimes and then I mess it up again. I'm sorry about that. With that advisement in mind, how do you wish to plead in regards to this violation of condition number 6 of this complaint and report in case 25M66?
Guilty, Your Honor, on behalf of my client.
All right, thank you. All right, based upon the statements and this advisement that I've given and the statements from Mr. Kurczynski and his counsel in regards to this complaint and report for the probation violation that was filed on July 27th, 2026, I will accept the admission from the defendant. I will accept the agreement from the parties that he will be making this admission and be sentenced to 20 days in the Teller County Jail of 20 days straight time, and then the matter will be closed out in its entirety. I do wish you the best, sir. I hope everything goes well after that, and that hopefully you can seek out some treatment that'll address everything. I know it's a difficult process. You can only just keep going forward and keep doing what you possibly can, all right? All right. I am going to order that you report to the jail by 7 p.m. tonight, unless, did he need additional time to?
At least a day or two.
If for Wednesday?
Yeah.
If we give him by Wednesday, I know he has a cat. He wants to make sure and
Okay,
add
all right.
So.
All right, so if you could report then by August 12th at 7 p.m.?
Yes.
Will that give you enough time? Everything? Okay, all right.
Five.
Yes.
Okay.
Any questions? No.
All right.
And I just need you to sign this order then for that. But otherwise, this case will be closed out in its entirety then, sir, all right? All right.
Thank you, Your Honor.
Thanks, Ms. Lynn, appreciate it.
Yeah.
I was just saying, like, you submit yourself to jail.
Mm-hmm. Okay. Right here?
Yep. So, like,
go earlier if you don't get it done. Yeah. It would be in violation. Right. Okay. Real important information comes up too. Okay. Yeah, I'll let you know. Check out. Thank you. Have a good day. Or do I leave now?
Yes, I think you're the lead.
Thank you, ma'am.
Everyone, thank you. Great day, sir. Okay.
Oh, thank
We ready to call any of our 3 o'clock matters? Oh, hi, sorry. I didn't see you guys come in. Come on. Don't think your attorney's here quite yet, Mr. Norman, so probably any minute now he'll be here. Okay, so we'll call you as soon as we can, okay? All right.
Your Honor, is Miss Compton on? I know that she's at the El Paso County Jail.
Yeah,
Okay, thank you, Your Honor.
right, as soon as she is. Let's see, who else do we have? Jackie McCall?
Afternoon.
Good afternoon, Mr. McCall. How are you?
I'm okay.
Good. This is case 24T34. Jackie McCall appears in person out of custody. Mr. McCall, let's see, you're here on revocation of probation. We had a complaint that was filed on July 1st. And we had previously, I believe, advised you on July 13th in regards to this, correct? Yes. And how did you wish to proceed today?
Your Honor, I'd like to just point out a couple of things on the summons itself, if I may.
Okay.
I'm sorry, on the summons itself. The summons has, one of the summons or the client non-compliance was on 6 and 7. And number 7 is per reports from Willow Bends, I'm sorry, the condition is I will submit to drug and alcohol testing as directed by probation officer. Per reports from Willow Bends, the defendant failed to submit 5-year analysis from 5/20 to 26 through June 24th. That has been retracted by Willow Bends. They have made it now, there was only one missed, which I have documentation for, but that's another story. So the revocation documents are incorrect or have not been revised on that particular number 7 subject.
Okay.
My other one was, and I spoke to Leah about this a little bit. I'm sorry, Officer Flynn. And that was on January 12, 2026, the defendant's probation was revoked and regranted for a period of 12 months. I went before Judge Kilgore on December 1st. I talked to the clerk and obviously I was here. I do not remember having any conversation or going over it with my probation officer afterwards as far as what that meant. And I do not understand what the violation was during that 60-day deferment.
So I'm confused.
Sure.
What do you mean? So you were in front of Judge Kilgore on January 12th, 2026?
Well,
yes?
Yeah.
Okay.
First on the 12th of December for my first revocation. Right. And then she gave me a 60-day deferment.
Well, okay. On December 1st, you appeared in person. Yep. There was according to the minute orders I read here, there was a hearing on revocation of probation. Defendant appears in person. Officer Flynn appears in person, not complying with probation orders, struggling with sobriety, set out for review. Mm-hmm. And it was set out for another date for the January 12th. So nothing really happened on that date other than you were probably advised about the complaint and report from the probation officer that had been filed previously.
That's possible. I don't have that documentation in my file. Okay. So, okay.
So you were probably just advised on that December 1st, 2025 date. Mm-hmm. So then you came back on January 12th. Right. And that's when it was set again for another hearing on violation of probation date.
Right.
And so on that day, that's when your deferred sentence, it looks like, was revoked.
Correct.
The minute order read that you admitted to violating the terms of your sentence and probation. Court finds it's a knowing involuntary admission. Sentencing arguments were heard. Court revokes the deferred, enters conviction, and sentences defendant to an additional 12 months of supervised probation, outpatient therapy, all the same terms and conditions apply. And so basically, it was the same terms and conditions that you had previously under deferred, but it was a full 12 months of probation.
Correct.
Going forward from there, and your sentence, your conviction just entered on that date.
Okay.
Yeah.
So I guess what my question is the violation of the 60-day deferment is what I'm not understanding.
So
I'm sorry.
No, it's okay. Let me explain. So what has happened is that, so you were put on a 12-month probationary period starting January 12th of 2026.
Yeah.
And then what was filed on July 1st of 2026 was a complaint and report stating that you violated the terms. And the terms were condition number 6, and that was per the report of Willow Bends. You submitted 2 urinalysis,
Okay.
one on February 10th and one on April 16th, in which the results were positive for ethyl
Right.
glucuronide and ethyl sulfate, which are consistent with the use of alcohol. And then per the reports from Willow Bends, the defendant submitted to a urinalysis on March 18th, in which the results were abnormally diluted. Therefore, the results were inconclusive.
Exactly.
Okay?
Right.
So that's the condition number 6, where they're saying it was. And then you said about condition number 7.
Yes, ma'am.
About failing to submit urinalysis between May 20th, 2026 and June 24th,
Yes.
2026. And so we can talk about that and whether or not there were urinalysis submitted during that
Okay.
timeframe.
They, I'm sorry.
So,
Thank you.
so
And I-
that's what they're saying.
Understood.
Okay. Those are the only 2 things that they're saying have been violated during that time.
Understood. Understood.
All right.
I have, is that okay if I speak?
Yeah,
I'm sorry.
go ahead. Yep.
I have reached out with a client complaint to Chief Ryan Mills and also to Jennifer Hernandez. Unfortunately, I did it backwards because I kind of jump stepped, didn't mean to. Anyway, so I'm waiting for their response. I was hoping to kind of go over more details with all this with them, and I haven't heard back from them. I'm sorry. And so go ahead.
Is that about the Willow Bends thing, or is that about?
It's actually about policy concerning the probation office. I've been on probation quite some time, and I've been able to observe things that I just feel like I would like to communicate to them. It's no grievance towards Officer Lynn. It's concerning how missed UAs are calculated and how they are held against you with written, documented proof as to why you weren't at the UA. And so that has been a contention of mine for a while that I've been trying to work through. Willow Bends has a policy that they can't forgive. Officer Flynn told me that the only thing they can forgive is medical, which leaves a really big gap for any other documented misses. For instance, going to Colorado Springs to take a person from the sobriety center to our doctor's appointment, breaking down 1 o'clock in the afternoon. I only have 4 hours and 15 minutes to do my UA. There's more to it than that. And I documented it, receipts, time, and it was not acceptable from, well, either party. And so I asked Officer Flynn, and then I suppose it was, I'd have to look at the dates. About 90 days later, I heard that her boss had told her that they could only excuse medical only. So that put me in a situation to where that's can be difficult to do it. I understand how people do, but they're documented. They're well documented. Some of the documentation I have not turned over to Officer Flynn because she had reported that she could not excuse those. So I was going to take that grievance, part of that one, and there's a couple of others, through the system, hopefully the right channels, to hopefully not take up the court's time with it. I do believe they will see that there is some potential impacts to their probationers. And I know a bunch of them. So that's where I'm at with that, including obviously myself. I do believe that it can be, my belief is it can be clarified. This is a very simple, it's not simple. There's some tentacles that I would like to address with them. I think that it would be helpful for me, and we should see where it goes from there. So if needed, I will request the court for continuance until I can get that information or some sort of response from them. I've got paperwork that I've been asking for 3 weeks from one of my providers, which I have not been given. The little bit of paperwork I do have, Officer Flynn provided for me. And so I was able to track through the documentation and see that there was a problem with how they had put 5 missed UAs, which came in on the summons as number 7, non-compliance.
Let's clear up number 7 first.
So, Your Honor, I did meet with Mr. McCall, and so what he and I had previously discussed, due to some challenges with demonstrating 60 days of sobriety, what we had talked about was let's do a behavior contract. After 60 days of clean testing and cognitive skills, then we would hopefully be done. We also talked about the financial barriers, the treatment, just kind of the barriers that Mr. McCall was facing. And so we decreased the UAs from weekly down to twice a month. I think what Mr. McCall is referencing is that didn't actually happen. I reached back out after our last appointment to get clarification because when he and I looked at it, he was still on a weekly frequency. And so even though I had sent an email to the provider saying, can we decrease these to twice a month to kind of remove that financial barrier, it didn't actually happen. So I think the treatment provider did go in and excuse 2 of the misses, which I wanted to let the court know today because I did get confirmation that that was an oversight. The UAs didn't get decreased. So that was later on. Can we go ahead and still decrease those? So there are, I think, 2 of the misses. I have to look at the dates here. They excused, looks like, I think June 10th and June 24th and 30th. So there are some that were excused. There were still misses on it. Looks like June 2nd, May 20th, and I think June 19th. And then unfortunately on Friday, I got an email saying that they are in the process of discharging him from monitored sobriety because he hasn't tested since May. So since this complaint and report was filed, there was an additional miss on August 7th, July 31st, and July 14th. So I agree with Mr. McCall that I think the amount of UAs on the current report is inaccurate based on the discrepancy of his testing not getting remedied to the twice a month. But unfortunately, there still have been misses. And if the court would like, I can go through to make sure that we have the correct count and file an amended complaint and report. Because unfortunately, there have been additional misses and it sounds like they're discharging him from testing at this point.
Which I am unaware of. But I have on my notes from Willow Bends that the sobriety monitoring for June, there was 1 unexcused, and that was 619. And that's all I have that I got from the reports that Officer Flynn provided for me. I'm sorry.
You're aware of the last time you tested, correct? You're aware
May
of the last-
27th.
So May 27th.
May 27th. It was in the documents, it says May 20th. I tested on May 27th with the negative UA, which is the day that I met with Officer Lee. I'm
So
sorry.
you haven't tested since May. What is it now?
I'm sorry.
What is it now?
That's a good question because
August 10th.
well, if they're saying 4, then I will have to go and see if that's.
You haven't tested since
No,
May.
right.
It's now August.
I understand that.
You're still on probation.
I understand that. And I should have, so I reached out to Officer Flynn and she said she thought the best thing for me to do was to go ahead and follow through with, which I have on all EOP, continue to do that. I think I'm down to 1 class to finishing, maybe 2.
Well, you're not
I know,
addressing my
I
concern.
understand.
sir.
I understand.
No, sir, you're not.
Okay,
You haven't tested since May.
that's right.
You're now in August.
I know. So okay.
So,
There's 2 UAs a month. I'm sorry.
no,
I'm sorry.
you
Okay.
have not tested since May,
Yes,
correct?
that is,
So
well,
you are not,
since June, actually.
no, you have not, your last test by your own admission was May 27th.
Yes, ma'am.
That's what you just told me.
Yes, ma'am, I did.
We are now at August 10th.
Yes, ma'am, we are. And if I could speak to that right quick?
No, you may not speak to
Okay.
that.
Okay,
I'm going to ask that they file an amended complaint. I will set it over for another date. We will have a hearing on your revocation. You can address that on that amended date, sir. You can choose to, if you are seeking out counsel, you should probably get that done ASAP.
okay,
But as of right now, you need to get back in compliance.
understood.
So I don't know where you're going to get signed up for that or not, but you are still on probation.
Yes.
You are not off of probation.
Yes, ma'am.
You need to meet with your probation officer.
Yes, and I
You need
have.
to comply.
Yes, ma'am. Yes, ma'am.
So get signed up, get back into testing.
Okay. Yes, ma'am.
She was working with you and trying to do a behavioral contract.
Yes,
You need to work on that.
agreed.
So the next time you're here in front of me, I want to hear that you are in compliance. You are not off of probation.
Understood.
So if you could do an amended complaint and report on that, it'll be crystal clear as to what has been done or has not been done. We will set a new hearing on the revocation here. If you're going to be applying for the public defender to represent you on this matter, you need to do that ASAP. I suggest you apply in person to make sure they get all of your information,
Yes,
sir.
the council did give me paperwork. I am ineligible.
Okay.
So I'll have to do it a different way.
All right, Mr. McCall, we will not be continuing this again. We will not be continuing this again.
Okay.
All right? All right, your next date will be?
September 14th at 3 p.m.
All right, September 14th at 3 p.m.
All right, guys, we did it. He's not going to comply. But thank you so much for coming out today. I appreciate it. I really do. I shall see you tomorrow morning. Bright and dark and early. Behave today. Be nice to people today. Bye, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. can count on distraction from my pain. 'Cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time.